Hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this Honorable Court are reminded to draw nigh and give their attention as the Court is now sitting. God save the United States, the State of Michigan, and this Honorable Court.
Well, thank you all for being here this morning. This is the first of 2 days of our March call. Our first case will be a case having to do with administrative law. We're pleased by the interest that that case has generated this morning. Thank you for being here for that.
They always are popular cases.
As always, there are 30 minutes per side for full grants. We only have one such case today, and 15 minutes per side for arguments on application, which the other 3 of our cases will be this morning. Furthermore, there is a 5-minute free fire period for full grants, which of course may be waived, and a 2-minute free fire period in arguments on application, which also of course may be waived. And the appellant in each case at his or her discretion may reserve a reasonable amount of time to reply to the appellee's argument. Your arguments, I believe, would be most effective if you recognized first that the justices are each conversant with the basic facts in your cases, and second, that the court is committed not only to resolving your case in a just manner under the law, but also to developing the law of our state so that it is equally just in its application to similar cases arising throughout the state in the years ahead. Our first case will be Enbridge Energy versus Upper Peninsula Power Company, and with the appellant, please go.
Good morning. May it please the court, my name is Lauren Donofrio. I'm appearing on behalf of the Michigan Public Service Commission. With me at council table is co-counsel Spencer Sattler. To his right is counsel for UPCO, Ron Bloomberg, and to his right is the Deputy Solicitor General of Michigan, Eric Restucia. I will be sharing my time with UPCO counsel, and I know to manage my own time.
How will you be sharing the time?
We're going to try to share the time equally as questions permit.
Okay. You keep track of the
Yes.
time that you use.
And the commission requests peremptory reversal in this case, or in the alternative grant of our application for leave. I will waive the free fire period. There are 3 points, however, that I would like to make today. The first is that in a case where you have sophisticated parties like Enbridge who have received notice of an action and then slept on their rights for years, they cannot be permitted to then launch a collateral attack of an order, of orders that they have the ability to appeal. Even if they didn't intervene, they still have the ability to appeal. And that applies even if the order were void, because they have simply not sought relief within a reasonable period of time, and they cannot be permitted to engage in that collateral attack. The second point that I'd like to make is that the Court of Appeals was wrong in its unnecessary holding that commission orders approving settlement agreements may be set aside if they affect non-parties. That somehow finality is less important in a commission case than in other cases. It's just not the case. The commission settled or approved 78 settlements last year. If we cannot have finality in settlement agreements, then we're not going to be able to settle those 78 cases. And of the rate cases that were just decided by the commission last year, 50% were decided through a settlement. All of those efficiencies that we all know how that works. I mean, we don't have to take everything all the way through a final judgment, through an order. And in rate cases, these orders are upwards of 100 pages.
Counsel, I know you have a third point, and I want to make sure you are able to get us to it. But while you're on this question, I just have a basic sort of architectural question, which is, when is this settlement agreement set to expire? Has it already expired? Would Enbridge have another opportunity at some future date to raise its Detroit Edison challenge in some future proceeding? If you could sort of just explain that basic architecture to me, that would be very helpful.
Sure. Well, the settlement agreements don't expire, but some of the terms within them may expire.
Okay.
And in general,
So it's
in rate...
evergreen.
I'm sorry?
It's evergreen.
Yes. I mean, well, it is, but when you, in rate making, it's sort of confined to that single case. So the next year, the utility comes in for another rate case, and all these issues are back on the table.
Doesn't that implicate your first question, the first point you're making? Let me ask you to make your third point, so at least we have all your points.
Oh, sure, the third point that I wanted to make. The third point that I wanted to make was that reasonable minds could differ in 2009 about the interpretation of the 2008 Act. Because when you look at rate making and how that happens, this court, the U.S. Supreme Court, umpteen Court of Appeals decisions have all upheld the principle that the Commission is not confined to any particular methodology so long as the outcome is just and reasonable rates. So absent...
Oh, wait a minute. Surely that is overstated. The Commission only has the jurisdiction to make rates within its statutory authority, correct?
Correct, and a statutory authority provides broad discretion to set rates so long as they are just and reasonable.
Except where the legislature says they don't.
If there's an express prohibition of a certain methodology, then certainly that would constrain the Commission's
Why does it have to be express? Why does it simply have to be within the confines of the law?
Well, the law does not enumerate all the different methodologies that may be employed by the Commission.
This very case at least raises the question whether the express authorization for this particular methodology in the gas regulation and its failure to authorize that same kind of methodology for electrical utilities suggests maybe that is not an authorized power. Now, that's what this case legally turns on, the construction of the authority of the Commission to engage in this particular methodology. So I'm not sure.
Well, I don't agree that that's what this case turns on, because...
Well, let's say I think
the underlying
that's what I think it is.
turned on.
Well, it turns on whether reasonable minds could have differed about what the law was at that time.
I'm not even there.
Okay.
I'm just at...
Well, if
whether-
we're looking
just
at that
a-
particular issue...
You want to know what I think?
Of course.
Okay. I think the legislature said rather explicitly that there is authority to engage in this particular methodology of adjustment for rate making for gas utilities. When it came to discussing electrical utilities, it didn't make that authorization. It suggested that the Commission report out something different. I'm accustomed to reading statutes so that when one thing is explicit and a parallel provision doesn't include it, in fact includes something different, I'm inclined to give that some meaning. Okay, so that's what we're thinking about here.
Right, and I understand that. But I think it is also important to understand the context of the area of law, and that application might not be quite as useful in the rate-making context.
What might not be? I'm sorry?
It wouldn't be quite as useful.
What wouldn't be?
The
words of the
idea
statute?
that because you have, and in here we didn't have a grant of authority, what we had was a limitation on authority. It didn't say the Commission may approve. It said the Commission shall approve for a certain subset of gas entities. So when we come at that and we, as a Commission, we look at what is our authority, and our authority has always been, we could have, prior to this statute, we certainly could have approved an electric or gas RDM. And then we get a statute that says for certain gas utilities, you may not deny an RDM. So that leaves the Commission to think, okay, well, for these we can't deny them, but we retain our discretion in other areas. This interpretation is not inconsistent with the new language that the legislature just approved in Act 31.
Counsel, this is actually quite convincing to me, but I'm curious why then there was, and maybe you don't know, why wasn't Enbridge Detroit Edison, why wasn't there a leave app filed, and why haven't you in this case asked us explicitly to consider whether it was wrongly decided?
In the Detroit Edison case, there were numerous issues, not just this issue, and we
You don't have to be
This is a
all.
big one.
I understand.
If this is how they do business, and all of a sudden they're told they can't, why hasn't anyone asked us to deal with that? If this is a shaky foundation upon which they want to build a shaky wall, why wouldn't we talk about the shaky foundation?
Personally, I wish that they had done so.
Okay.
My understanding is...
You could ask us, you didn't ask us to
You didn't even
overrule
hear
it.
ask us to reconsider the
case,
propriety of
That
that
is
decision.
true, and I think in part because we did not appeal that decision, feeling was that perhaps it was inappropriate for us to ask that relief in a case where we're talking
But you're
about somebody
asking for
else's
it now.
collateral attack.
In this argument, you're saying,
what I'm talking
ignore the
about-
elephant, but
But
feed
what
him
I'm
peanuts.
saying is that if Dodge applies in this case, then what we're looking at is not whether the whether the commission had the authority. We're looking at whether reasonable minds could have differed about whether they had that authority. And what I'm trying to explain is why reasonable minds could differ and why the interpretation of the statute that the Court of Appeals came to was, while that's the argument that carried the day, that doesn't mean that there were not other interpretations that could have also been reasonable.
Okay, counsel, I understand that, but what concerns me is if Detroit Edison is right, even if reasonable minds could have differed at the beginning, let's assume either that Detroit Edison is right or that we can't we're stuck with it because nobody's asked us to overrule it. If that's the case and these RDMs are now illegal, then how can it be that a settlement agreement with a regulatory body, as opposed to between two private entities, can alter the law? Like, you can agree to something that ultimately turns out to be illegal and perpetuate that forever? That's why I was interested in the question about...
That can happen all the time, though. If you look at MCR 2.
What couldn't happen is that the commission, after Detroit Edison, approve an RDM, correct?
Until April, that would be the case.
Well,
You'll need to respond to arguments, but I do want you to know that you're leaving your fellow advocate very little time.
I am aware, and we have discussed
Okay,
that
please
would be a
proceed.
possibility. When you look at the new Act, in Act 341, what the legislature did now is to say for certain electric utilities that have less than 200,000 customers, the commission may not deny their request for an RDM, which, again...
How does that help you with your Detroit Edison argument, then?
Because it's not inconsistent with the argument that the commission made that we don't have an express denial of our pre-existing authority.
Except Detroit Edison has.
Except the Detroit Edison case.
That's
which, admittedly, I believe was wrongly decided.
Okay,
But
well, I'm
within
glad
the
to hear that
constraints
now.
of what we are arguing today...
If Detroit Edison is good law and you haven't challenged it, I don't understand the position being advanced that a process that the commission could not, under Detroit Edison, advance as a part of its authority to approve in the first instance can be circumvented if the parties come to the commission and ask them to bless an agreement that the commission could not initiate.
Because the petitioner comes too late.
I also don't understand the more limited proposition that the settlement agreement can apply only prospectively, which is a proposition this Court's been very strong in its objections to.
When you have an order of the commission, there's something called the rule against retroactive rate making, and our opposition has cited to MCL 462.24 for the proposition that at any time you can rescind an order of the commission. However, MCL 462.24 is constrained by its terms by MCL 462.22 by 22. And 22 provides that if you have an investigation and you find that any order, any rate, any service, anything is wrong, it's unreasonable, then the only order that the commission may give, it says it shall determine and by order fix and order substituted therefore such rate or rates as is or are just and reasonable, and which shall be the maximum to be charged in the future. So anybody at any time can come into the commission and say, look, you ordered these rates. Those rates are not reasonable. And the commission can say, you're right, those are not reasonable. And from this day forward, those will no longer be the rates. What the commission cannot do is say, you're right, they were unreasonable at the time that we ordered them, and so we're going to retroactively say that somebody else should have paid them because the allocation is wrong, or change the amounts. We only make those orders going forward. Now, in the case of an appeal, that can happen because you're still within the same case. But when the commission decided this case in 2009, and Enbridge slept on its rights until 2012, we're too late. I mean, is there a limit on this? Could they take a 1995 order and say, you know what, that order in 1995 now based on this decision is illegal?
Can I ask you about your collateral attack argument? It's kind of interesting, except it seems inconsistent. When the petition for the rehearing of the August 14, 2012 order occurred, the administrative law judge concluded that Enbridge had waived its right to collaterally attack the RDM because it hadn't intervened.
Correct.
Your client, the commission, however, rejected that position and held that the Enbridge had filed a proper complaint under its own rules, but granted summary disposition on a different ground. Now, isn't that a procedurally odd position?
No, it's not. And the reason is because when you're asking for rehearing, first, they weren't able to do that because they hadn't intervened in the case. They weren't properly a party to seek rehearing. But when you they could have filed an appeal. They didn't file an appeal. They didn't intervene in the first instance. But that doesn't mean that they can't say this rate is unreasonable. So they can file a complaint about an order and say that the rate is unreasonable, and then going forward it would change. That is different than a collateral attack that asks for retroactive relief.
That's what the ALJ concluded, that they were making a collateral attack.
Well, they were in the 2012, because in 2012, when they asked for rehearing, they were asking for rehearing of the reconciliation order. That was the order that the commission entered that enforced the settlement agreement that it approved in 2009, that reconciled 2010 rates. The commission had also at that time, as of December 31st of 2011, said there will be no further RDMs. We don't have authority to do that. But because
you have authority to approve them if the parties come to you with them under your theory, right?
Well, under our theory, however, Detroit Edison said we were wrong about that, so we follow that law. But that does not mean that the settlement agreement that was entered into in 2009, that nobody appealed, that Enbridge could have intervened in and did not, that could have appealed even if it did not intervene but did not, because the state of the law at that time, this was a brand new statute, the state of the law was unknown to the parties at that time, and numerous parties, the commission, the parties' lawyers, the ALJs, all interpreted the act in a way that was different than what the Court of Appeals ultimately looked at. And then in 2012, when the settlement order from 2009 was enforced, they said, well, all right, we looked at this Dodge case, and this Dodge case says that if there was a question about what the law meant at the time, if there was an honest dispute among the parties on what the law meant that was decided through settlement, we are not going to change that. We are not going to overturn those settlement agreements, even though years later it turns out that one of the parties was right and one of the parties was wrong, because finality is so important.
Let me see if I can clarify what I think your position is. Your position is that Enbridge cannot get retrospective relief. That is, they can't get a refund for whatever they've already paid from the period of the settlement agreement, 2009, going forward, but they could come in at the next opportunity and say that when you're this current rate, which is based on the old settlement, is unjust and unreasonable based on the authority of Detroit Edison going forward.
Correct.
That would be fine.
Yes, it would.
So you're not saying the old settlement agreement exists forever. It could be challenged on the basis of Detroit Edison going forward in a new rate making.
At any time.
But they can't get retroactive relief.
Correct, because what would happen...
No refund.
They can't, because somebody else would then have to get surcharged. So, because it's not the utility's fault, it didn't, for example, charge the wrong amount. The utility company charged the amount that was approved by the commission. So the utility hasn't done anything wrong. So they have to make up that revenue somehow. So if this individual doesn't have to pay it, then somebody else is going to have to pay it. But then they're paying it without any notice that they would have to do so. And then we get into due process arguments, and that's why there's a rule against retroactive rate making.
What is the effect of the Court of Appeals decision below on that very point?
I'm sorry, say that again.
I understand the argument,
Yes.
as clarified by my colleague. I'm asking now the question, what is the impact of the Court of Appeals opinion on retroactivity?
The result is that all of the settlements agreements that have been entered into that decided issues of law that may at some point be challenged in court, and it may be found that the commission or the settling parties were wrong, are all now suspect. And they are all now subject to challenge. We have this new Act 341 that have made sweeping changes to gas and electric rate making that goes into effect in April, and there are constant.
My question.
We're all worried
is a
about how we're
limited
going to
one,
do that.
Not the global. I'm just asking.
In this particular
Does
case?
this Court of Appeals decision mandate that the rate making that was settled by the RDM and being challenged here be undone and retroactivity occur?
Yes.
All right. Thank you.
Wait, really? Sorry. You think that the Court of Appeals opinion must apply retroactively to invalidate your settlement agreement? I thought your view was no. I thought your answer to me.
If it is undisturbed.
I asked specifically if the what the Court of Appeals decision here, if left intact, requires retroactive rejiggering of the rates for all the parties that were affected by the rates.
It will in two ways. I believe in their main brief, Enbridge indicated that their monthly bill was $5,800 higher because of this. Well, if we have to unwind this whole thing, somebody else is going to have to pay that $5,800. It's going to have to come from somewhere. But more importantly,
let me ask
the whole settlement agreement's void.
If it were beyond question that the commission was without authority to do something it did in creating a rate, and that was found to be ultra-virus, illegal, wouldn't we have the same situation? Are you saying that any time the commission oversteps, and clearly so, oversteps its statutory authority and commits to a rate making that is void ab initio from the start, don't we have the same problem?
We do.
And what do we do in that circumstance?
In that circumstance, it would depend, and if you look at MCR 2.612 sub C, that provides that a party can seek relief from an order or judgment for the reason that the judgment is void. And I think that's subsection 1D. But that has to be brought by the terms of the rule within a reasonable time.
Well, they're reasonable.
So if it is not brought...
this is a laches argument you're making.
It is a laches argument.
If the commission clearly violates its statutory authority in setting a rate, even though it's void when it's created, what if it's not a late? If the challenge is not late? Still, there's a period of time when it was in place, rates were assessed. Don't you have a retroactivity problem in that circumstance?
I think you do, and I think that's where Dodge comes in.
Okay, thank you.
Thank you.
Your time is significantly expired. We'll give you an opportunity to respond to some questions if the court has any. So would you please come up? But you have no additional time at this point.
Is there any question for him?
I'd like to see.
I'll ask.
I'll do so. Does anyone have any questions?
Can I
No.
try to respond to the questions that the
No.
court
No,
has already
no.
asked?
Nobody asked?
Good morning, Your Honor.
Are there
I'm
any
Ronald
questions?
Bloomberg, appearing on behalf of UPCO. Thank you very much. I'd be happy to
Okay,
answer
I'm
any
sorry your
additional
time has
questions if
expired
anyone
here.
has some.
Oh, you know what? I'll help you out. I'd like you to. You know what? I'd like you to respond to the question that the court has asked.
The court's asked a number of questions. I think that what the court's struggling with most of all is the question of retroactivity and how this ruling applies to this case, which was an RDM with regards to rates for service rendered in 2010.
If you're going there, tell me if we have a situation of pure, where the legal question at issue here, whether they had the authority or not, is not in question. The hypothetical is the commission clearly had no authority. It creates a rate. That rate is timely challenged, but once that challenge has occurred, rates have been paid. We have a retroactivity problem, do we not?
Yes, Your Honor.
And the answer is, once the illegal rate has been approved and the illegality of the rate has been brought to the attention of the commission, its authority is what? Its obligation is what?
In your scenario, I would equate it to a utility which is charging a rate which has not been approved by the commission,
Except it had been,
but not
legal.
within its
Yeah.
jurisdiction.
And what happens
use the
in that
word
circumstance?
void. And really,
What happens in
for
that
rates that have not been approved by the commission, the universal standard is that the rates must be just and reasonable. That's the standard under the statute. That's the standard under the Constitution. I would refer the court to the case of Northern Michigan Water Company. I believe, I don't have that site with me right now, but I believe it's 381 Mich, and excuse me if I don't have the page.
Is that a case
But that was a, yes, Your Honor.
I'd like to just cut through this, at least from my point of view here. Is there any good argument to be made from public utility law, constitutional law, administrative law, or political science precepts that an administrative agency ought to be able to expand its own power via a settlement? To me, that's the question that lies at the heart of this case, that permeates this case. What is your best answer to that?
The commission has the power to set just and reasonable rates. There was a genuine dispute as to whether the RDM...
Cabined, I presume, by what the law has to say concerning just and reasonable rates, right?
Correct. Okay, there are constitutional standards as to what's for just and reasonable rates, and that they cover the cost of service and provide a fair return on investment. Those are federal and Michigan standards. If this court were to not apply Dodge, to apply Detroit Edison, our position would be that the test is whether the resulting rates were just and reasonable and met those constitutional and statutory standards. And we believe they
So a
did.
statutory violation, a frank statutory violation that still results in a rate that isn't unreasonable is fine. That's what you're arguing.
If it wasn't challenged, is what you're arguing, right?
If it wasn't properly challenged,
Right. So I want to put this hypothetical, which I think occurs all the time. So let's say a prosecutor, I mean, it shouldn't occur. A prosecutor and a defendant agree. There's a statutory maximum for a crime, 10 years. Prosecutor and defense attorney agree. I'm going to dismiss this other count on which you'd be facing a 25-year sentence. And you're going to plead to this 10-year crime, but your sentence is going to be 15 years. Now that's illegal. The judge should not accept that. But if the judge does and nobody challenges it, then we would say it's final even though it's illegal unless you can bring some sort of collateral attack showing why you couldn't have raised it at the right time, et cetera, right? So we would then be in a 6,500 motion. But the burden is on the defendant to say, hey, you can't sentence me to 15 years for a 10-year crime, even though it's illegal. So isn't that your argument? Your argument is it's on Enbridge to have raised the illegality in a timely fashion. Otherwise, they can challenge it the next time, but they can't challenge it retroactively.
Correct.
That's what I
Are there any further questions? Thank you.
Thank you, Your Honor.
Appreciate it.
May it please the court, good morning. Sean Gallagher of Clark Hill PLC. On behalf of Enbridge Energy Limited Partnership. With me this morning is in-house counsel to Enbridge, Mr. Charles Drayton, who is also a Michigan attorney, practiced here in Lansing for several years. Your Honors, Enbridge opposes the applications for leave, and I guess I would like to make perhaps 3 points and then waive the remainder of the free fire period. From Enbridge's viewpoint, because of the Railroad Act that sets the requirements for challenging an unlawful order, Enbridge's challenge, filed as a petition for rehearing or reconsideration in August of 2012 and refiled in October of 2012 after Detroit Edison was decided, is not a collateral attack on the RDM. And I think practically speaking, the RDM had not raised any rates. The RDM approved in 2009 and then again approved for rate increases in August of 2012, had not raised any rates at the point that Enbridge intervened. So to suggest that Enbridge slept on its rights, when in the rate-making context, rates must always be just and reasonable, and under the primary jurisdiction doctrine of this court, in the Valentine case involving a case where a ratepayer of Michigan Bell had sued in Oakland County Circuit Court, that case was dismissed and told, and the ratepayer was essentially told, no, you need to go to the commission to seek redress of your grievance. If you're aggrieved by a commission order, then you need to go to the commission. So this is not a collateral attack.
How do you unscramble the egg? Counsel makes a good point. This isn't a private entity where if they make a mistake, they pay for it out of their pocket, right? So this money that might have been overpaid by Enbridge has to be made up somewhere. How do you do that? How do you unscramble the egg and reassess?
Thank you for asking that question, Justice Sarah. The commission can unscramble the egg by processing refunds. So to the retroactivity question, really, right?
Well, no, that's what you want, a refund, but how do you make up for the refund?
Well,
who pays those rates? Ms. Donofrio said, well, who's going to pay those rates?
It's the responsibility of the utility.
And that's my question. How do they do that?
Well, the utility collected the rates and they were unlawful. The utility needs to refund them. It doesn't mean they need to go back and charge the remainder of their customers for rates that they unlawfully collected. It just means they don't get the benefit of that.
But they were sanctioned at the time they collected it, right?
They were sanctioned by the The commission.
Yes.
Right, yes. So, but the retroactivity issue,
Are you, just to make it real simple, are you saying at this point they have to extract from somebody else, another ratepayer, enough to compensate you for what you believe your company has been, your client has been overcompensated? Is that what
No.
you're arguing?
no,
Well, sort of say it in plain language so those of us who aren't in the industry can understand what you're saying. What happens? Your client has been overcharged, let's say $5,000 for this period. Somebody hasn't been charged $5,000 as a result of that. How does the commission make it right now?
just so I understand. Our client was charged, for example, $5,000 more than should have been.
You're saying they didn't have the right to make that extraction from my client. Commission, I now want you to do what?
Order the utility to refund the $5,000.
I'm sorry?
Order the utility to refund the $5,000 to my client, to the ratepayer.
Where do they get that money from? I think the essence of the question is, you put forth this concept. Where does that money come from, and how do they do
The
it?
commission puts it out of its budget?
Not the commission.
Well, where does it come from?
Comes
Where does
from
the $5,000 come from?
It went to the utility in the first instance. The utility collected it as part of its rates. The utility needs to disgorge it. It just
Okay,
needs to give it back.
so the utility that benefited from the RDM, or whatever it is it? Yeah, RDM, has to disgorge what it collected, and then it goes over to your client.
Yes.
Has that ever happened before that you're aware of?
Yes, it has.
Tell us about it.
But they had permission to do it, right? They wouldn't have done it if they didn't have permission to do it. The whole idea of the RDM is that you're discouraging use that's going to impact your revenue, and that it's going to be made up in a different way. So they wouldn't have taken this path if the commission didn't sanction it. So why should they now, after having permission to do it, suffer the loss? And the whole notion of the Public Service Commission, isn't it to guarantee that these things don't happen? Right, that they're only going to they're going to operate, at a reasonable rate of profit.
And that the Public Service Commission will act within the strictures of the legislation that authorizes them to approve just and reasonable rates.
So just and reasonable in the future is going to be whatever it takes to make up for what you're spread out over the other utilities customers, what you overpaid.
No, I don't think the other utility customers should be responsible for paying a refund for an unlawfully collected rate. I think the utility has the responsibility of simply refunding.
It wasn't unlawfully collected. It was unlawfully authorized. But the utility was acting with the sanction of the commission, right?
The utility was acting with the sanction of the commission. So there, and this, I think, touches upon the retroactivity issue. There is a prohibition against retroactive rate making in Michigan under the law.
All right.
However, retroactivity does not apply to an unlawful order. The order.
What is the authority out there that helps us understand how, if this Court of Appeals opinion, which relies on Detroit Edison, stays in place, how this transaction gets unwound?
So, for example, in 2010, the Court of Appeals in the Michigan Environmental Council versus Consumers Energy Company case stated that the MPSC can mandate a refund of monies paid pursuant to rates set under an unlawful order.
Counsel, good morning. I just want to, I like to keep things simple because I realize this is a very complicated, kind of intricate case, and my goal is to try to simplify things as much as I can, and I think you're doing a very good job of helping to allow for us to understand the complications of this. So thank you for that. But it's a simple question, but I think there's a deeper meaning to it that I'd like you to expound upon, and I think this is something that's troubling the court. Why did Enbridge wait? There was notice. This wasn't an issue that was secret. It was highly public. Why did the company wait?
I don't know, Your Honor.
What would you guess would be the reason that they would wait?
I think the expectation, based on the statute, that a pilot accounting mechanism, an RDM, at least for electric providers, is that they could collect the information and track it to see.
But this isn't, that's what the statute says. This is something different. This is the equivalent of the authority given to the commission to do RDMs for gas companies, right?
This is the equivalent.
But what happened in this case? They did by consent what the other provision governing gas providers allows them to do explicitly.
Correct.
So you may not know why your client failed to intervene earlier, but why isn't that really a problem for your client's position at this point when it's easy to say, well, I haven't suffered any harm, but the mechanism is now been authorized, which your client claims was not properly authorized, that may in the future injure them. So why does your client get to sit on its interests, so to speak, for a couple of years until the injury manifests that was clearly contemplatable when this mechanism was approved?
Your Honor, I think it goes back to the railroad statute and the fact that Commission's orders, and I'm reading from Section 25 of the Railroad Act, Act 309 of 1909, all fares, charges, and classifications and joint rates fixed by the Commission and all regulations, practices, and services prescribed by the Commission shall be enforced and shall be prima facie lawful and reasonable until finally found otherwise in an action brought for the purpose pursuant to the provisions of Section 26 of the Act. And so Section 24 of the Act, the Commission may at any time upon application of any person or any common carrier.
But Counsel, do you understand the concern that I think is kind of being brought forth, which is the issue of finality? Do you understand, like, if you could kind of get into that and help us to understand, you know, how is it once a decision is made by the PSC, I guess the concern is that how does it allow for, you know, utility providers and entities like this to be able to plan if you can have an action that could come years down the road? I think that's something that we'd really like to hear a little bit more about and understand your position on.
So I appreciate that, Justice Bernstein. The finality concern, I think, is it's an interesting one, particularly in the PSC context, because rates must always be just and reasonable, and at any time in the future, there can be a challenge. So any time in the future is well, in the Dodge case, they had 17 years had passed. In this case, nowhere near that long a time had passed.
Well, there's a lot less injury here because, at least according to what opposing counsel says, each time these things are adjusted is an opportunity to say no more. That then eliminates the retroactivity problem, and it creates an immediate, causes immediate tension on the supposed illegality of the prior approved RDM. Why isn't that the best way in this kind of regulatory regime to proceed? Your client didn't intervene to challenge the original one, but when it's time to renegotiate that, then you stop it. Why isn't that the most rational way in this regime to proceed?
Well, Enbridge could have waited until the next general rate case filed by the Upper Peninsula Power Company to challenge.
Why didn't it sleep on its rights otherwise?
I think because the rates must be just and reasonable, and to Justice Bernstein's point, I think.
And why aren't they just and reasonable other than the fact that they aren't authorized by the statute?
Why are they not just and reasonable?
Yes.
Other than not being authorized by the statute?
Yeah.
I think it really goes back to whether or not they're authorized by the statute, and it requires the Commission.
Well, if it's an abstract proposition of just and reasonable, then I'm not sure I understand your argument.
Is there any time limit on your argument that you can retroactively attack a settlement? So I assume Enbridge Energy is going to be in business for 100 more years. So 100 years from now, Could they say, I'd like my refund from, because it was illegal when you charged me this rate in 2012? In 2116? 17? I guess we're in 17, sorry.
At some point, it reaches, I think, the length of time after an agreement is entered that sets rates.
At some time.
At some point.
We'll know it when we see it, kind of. Have a good gut feel about it one day. It's not a perfectly satisfying rule for us.
No, I appreciate that, Justice McCormick.
You're not offering much help.
Well, why isn't your, I mean, I'm not going to make your arguments for you, but I don't understand why your response at least is not in part the fact that you interjected as soon as the Public Service Commission entered a specific order with which you disagreed, and the Commission itself indicated that your objections were filed properly and that they alleged properly that you had been harmed by improper rates or charges.
I think I did advance that argument in our papers,
I missed
Your
it if
Honor.
you did.
You didn't advance it here. You may in your briefs.
Yes, Your Honor. Well, the fact is that Enbridge did seek redress at the Commission.
Do you have anything further you'd like to say in the larger issues of this case? I guess, speaking for myself, as I suggested to your opposing counsel, I see the issues being fairly big ones concerning the authority of administrative agencies to engage in settlements that result in the enhancement and expansion of their authority. I haven't heard any comments from you concerning that, so I assume your briefs have spoken for themselves. Is that right?
They have, and I make that point, I think, specifically in our initial answer to the applications,
Okay.
if not also repeating that point. That is the larger constitutional issue that goes to the separation of powers between the legislature and the executive and the Commission's authority from the statute. I don't have anything further on those big picture issues.
Any further questions? Thank you. Thank you very much.
Thank you, Your Honors.
Okay, we'll move on to the next case. Thank you.
Thank you.